Nevada Transportation Authority's regular agenda meeting for October 9th, 2025. We are on docket item number 153. At this time, I'm going to take some public comment to be a little respectful of people's times. And I appreciate everyone indulging us to allow staff to have lunch. So with that, we'll start with Ed Finger. Ed Finger, are you here? Thank you. Come to the table. Please introduce yourself and if you'd spell your last name for the record, and we're going to keep time limited to 3 minutes and make sure it's substantive of the item.
I'll do my best on substantive. My name is Ed Finger for the record, last name Finger. I am the Chief Strategy Officer. It's hard to hear your own voice, isn't it? I'm the Chief Strategy Officer of the Las Vegas Convention and Visitors Authority. The LVCVA, as the tourism authority for the greatest tourism destination, the owner of the busiest convention center in America, the owner of the Las Vegas monorail and the Las Vegas Convention Center Loop, strongly supports and encourages multimodal transportation options in the Strip Resort Corridor. Strip Resort Corridor is a long way away from being optimized transportation-wise. It is our goal in all things to improve the visitor experience, to be better, to be the best. We think that this system does that. The underground portion of the system, which has already been approved and is, 13 miles built down Paradise, around the convention center, et cetera, is going to improve Strip Resort Corridor transportation. It is going to reduce congestion. We have operated a like system on the convention center for 3 years. We've moved 3 million people. We have an impressive safety record. It's proven itself. What's in front of you today will allow the Boring Company during this construction period to accomplish those same outcomes, to improve transportation in the Strip Resort Corridor, to reduce congestion. And because of this simple issue that each of these rides has to spend at least some of the time in a tunnel, it will reduce congestion. So I appreciate you allowing me to speak. We strongly support this and we appreciate your consideration.
Thank you, Mr. Finger. Appreciate it. Next, Mariano Locasio.
Good afternoon, everybody. Last name is Locascio. I've been listening what the AG said earlier, and what is it stopping all the rest of the carriers back here just to take the meters out and do per capita? That's my main, that opens a whole can of worms. They said it's per capita, but then when you read it, after certain miles, they charge more. To me, it feels like a taxi. And when you look around the valley and see all the homeless, and what are we trying to achieve? More unemployment and more of less transportation, people being employed. Thank you.
Thank you, sir. Next, we'll call Paul Adams.
Good afternoon. My name is Paul Adams, ADAMS, last name. A little shy talking in front of people, but I will say I am a driver for Yellow Checker Star Taxi Company. In fact, I'm a driver for Wheelchair Accessible. And I feel, my personal opinion, if they approve this Tesla tunnel, it's going to make it a lot more difficult for us taxi drivers to make money. I just worked a shift. I'm still on shift. Every taxi stand that we go to, slow. It's just not enough business. Adding another industry, which is fine, but to compete against what they're charging would eliminate, I feel, this industry. And it's not just the drivers, it's staff, it's mechanics, it's everything that's involved in the taxi industry. So that's just my opinion. Thank you for your time.
Thank you, sir. Appreciate it. Next is, looks like R. Uffield. Nothing for you. Gotcha. Thank you. About Mike Krilgo? Not here? Okay, perfect. Thank you. Michael Balin.
Good afternoon, Michael Balin, Bailin. I am the general manager of taxi management. We own 7 local cab companies. We are the largest taxi operator in Nevada. We have approximately 50% of the market here in Vegas. We have approximately 2,400 hardworking men and women, both employees, independent contractors. Approval of the Paradise Transportation application would negatively impact their ability to support themselves and their families. I wasn't really clear about when the applicant, if they can also pick up at, like, say, Caesars, as they said, and take somebody to the tunnel. It's just like a taxi cab at that point, in my opinion. I've been managing people. I've been in the industry since 1992. I can tell you drivers are not going to do exactly what they're supposed to do. It's just the nature of it. They're going to find ways to game the system. There's no way that Paradise can cover its costs by doing $5 to $10 per person. This is nothing but predatory pricing, which seeks to drive out competition of businesses. This is a complete direct, it's a compete directly with the taxis, limos, and TNCs, as passengers are going to easily take the less expensive ride. So this is exactly what Uber did. They got into our market. They had these very low prices throughout the country. They closed down a lot of cab companies. And then when they close them down, then they jack up the prices. Right now, it's going to be exactly the same as Uber, where Uber, there's all these unlicensed drivers. They get stickers, they pick up. I know Todd and his agency and his sister agency do the best they can with their budgetary issues of trying to solve this problem, but it's rampant. And Uber doesn't care because their goal is to drive out companies like ours, just like the Boring Company is going to be as well. There's no need for any additional transportation, just like Paul was just up here talking. Vegas is struggling, and we all know it. And to add something else that's not needed, it doesn't seem like the time or place. When Mr. Musk built these tunnels, you guys approved it. He had said, this was going to reduce congestion. Now they want to come out there. He knew at the time this wasn't going to happen overnight, and now they have to do it to stay afloat, I guess. I mean, this is the richest guy in the world. He's got money to keep going. They don't need to come out of the tunnels. It should stay in the tunnels. That's what was approved. They're just becoming a regular old taxi cab company. I know the definition of what a taxi is. It's just a cover-up. And we really believe you guys should deny this application. Thank you.
Thank you, Mr. Balin. I appreciate your comments. Melanie Rogers, next.
My name is Melanie Rogers, Rogers. I'm a taxi driver of Yellow Cab for 17 years. I've seen a lot of things change. I think adding a possible unregulated company again is not fair, one, to the airport. They're losing money with Uber and Lyft, millions. We need to get regulation. I saw the Uber driver get shot in front of Treasure Island a while back. We're not supposed to carry. I'd love to carry. I leave it at home. That's the rules. So we need to get a handle on these things. There's also another transport company called Buggy. I don't know if you're aware of it, Sahara and Eastern. Look it up on the internet. We have a lot of rogue locals in black sedans that do these things for cash that are Uber and Lyft. We're not taking control of it. I feel it should be denied until all the tunnels are built. At least give us a chance. It looks like, no pun intended, a loophole, what they're requesting on their part to do this in and out of the tunnel thing. It should be waited until the entire thing's under construction. I have a lot of other rants that don't pertain to this. So you folks have a good day.
Appreciate it. Thank you very much, Ms. Rogers. Next, Christian Gomez. Going once, going twice. Christian Gomez? Nope. All right. Patricia Erickson. Next. You want to wait?
I was ending the pursuit.
Jonathan Sellis. Jonathan Sellis. We'll mark that as absent. Athena Iliadis.
Good afternoon, Athena Iliadis. I'm one of the board of directors of Taxi Management, more informally known as YCS. My dad drove a cab for 28 years before starting this company, shortly before I was born. He's recently retired and passed down the torch to me. We're a family-owned Las Vegas local company. This highly impacts us. We are highly regulated by the TA. If someone wants to come to Las Vegas and operate taxis, they should also be regulated by the TA. We cannot lower our pricing. We cannot raise our pricing without a process. And in order to operate as taxis, I feel that Paradise should be seeking medallions through the taxi authority. They don't have an app, which was the main argument for Uber and Lyft. They're a tech company. Without an app, are they truly a tech company? We don't know if these tunnels will be finished. There's several boring company projects throughout the United States that failed, most notably Los Angeles. They want to pick up and drop off at non-existent tunnel portals because the tunnels haven't been built there yet. So it seems to me that this is not the proper entity to be applying for taxi service. And also this application is incomplete. Thank you for your time.
Thank you very much. Abel Nagusi. Mark that as absent. Juan Gomez. I'll mark that as absent also. Armenta Caesar.
Hello, everyone. My name is Arminta Caesar. That is Ceasar. for the record. I am I want to say proud driver for YCS. I have been with them 3 months. And in the 3 months that I have been driving, I have seen a decrease in the need for transportation due to tourism being down. We are competing with Uber and all the other ride share. And just to piggyback a little bit on what Mr. Balin said, I see they said that it would be a 7-year progress. So that's going to phase us out in 7 years. And due to YCS, I now have income and a way to help and raise my family. So I don't want that. Like she said, give us a chance. With the rates, we cannot compete with $5. So I see that as a way of them phasing us out and increasing the prices. And again, what about the airport tax? At this time, it is just not needed. Thank you.
Thank you very much. Peter Sellis. Mark that as absent. Eric Tong. Or Edric Tong. Mark that as absent also. Alan Waxler, do you want to go separate or with the attorneys? I didn't know if you wanted to be joined in with everyone else. Thank you. Appreciate it. Thank you.
I don't need anybody else except my attorney. Alan Waxler, AWG Ambassador. Allow me to pull up my notes. Thank you for allowing me to speak. First of all, I'd like to say, what are we doing? I have been part of this organization since 1998. I don't get in trouble. I follow all the rules. We self-report if there's an issue. And I look upon this organization to protect me, protect my business. And I feel like we're rolling over because, as Garrett so eloquently described, billionaire, that has nothing to do with the company. It's about what the action is. And I'm just shocked it's even got this far. This organization petitioned the commissioners for a boring company to provide transportation underground. No harm, no foul there. Why are they coming onto the street? What is the purpose? Because time is not on their side? When Uber and Lyft showed up, it was a disruptor. This, I feel, is somewhat of an annihilator. This is going to hurt a lot of tax-paying people, hardworking employees from all the companies. I don't begrudge them one bit to do what they say they were going to do, but that's not what's happening. They're changing the game, and now they want to come onto the street. And the whole purpose of petitioning the city to do this was to relieve congestion. Now they're going to put 100 some cars on the road. How does that relieve congestion? It's contradictory to what the reason that we're building these tunnels. I don't have a problem with this organization going forward as they said, but I just don't get why we're rolling over because the wealthiest man in the world is behind it. It's never been that way. We've always allowed a voice. I reneged on my
I'll let you go ahead.
on my position as filing a PLTI because Ms. Rushton's PLTI was going to stand. And then all of a sudden I get blindsided and we dismissed that whole process. I need to understand just a couple things and I'll finish quickly.
Please.
Yeah. I just want to understand the utilization of these stations. Is it just because they said they're going to build the stations and then they're going to be able to go through? Going through the tunnel, I get. Right now, there's what, 3, 4 tunnels? We really need to stop and look the effect that it's going to have, not so much in the traveling public, but the established companies that have been paying the fees and following the rules and doing everything we need to do. And I'm really sad that this day has come, that I've got to sit in front of this board and beg for my existence. Thank you.
Thank you, Mr. Waxler. Next, Joe Bonifaz.
How you doing, Commissioner? All right, so I'm a taxi driver, been taxi driving for about 3 months. You guys are gonna do what you guys are gonna do. Technology, AI will get there, transportation will change, everything will change. It's an ever-evolving world, especially here. So I just believe there should be some type of remuneration, some type of compensation. I don't know, basic income was something that was talked about in the presidency last time. I don't know, that's an idea. You can't just exterminate us, leave us out, right? So that's something I feel like no one has really talked about, The plan will probably move forward, whether it's now or 7 years from now. There just has to be some form of, something for us, whether it's, universal basic income or, the Tesla fleets, right? They're going to be robo-taxis, that could open jobs, yes, Elon's a billionaire. He will continue to change the world. I have no problem with that. I think that's really cool. But, I'd like to own a fleet of robo-Teslas at some point, have them out.
If we could just keep it to this item, not robo-taxi, we're not there.
So that's all I wanted to say. There has to be something given to, especially all the people that have been doing this for 20 years, families and all that. Unless your whole plan here is just to get richer and keep us poor. And that's it. Thanks.
Thank you. Juan, sir.
Hello, how are you?
Good. If you just state your name, spell your last name for the record.
I'm Carlos Beltran Gomez. All
Can you
right,
spell your last name for the record, please?
Peltran,
A little slower, I'm sorry.
Peltran.
Thank you, sir.
Okay. I was listening the way they want to do the rights. And I heard that as long as they use the tunnel, they can take the right. So that means they can go the other way around, 2 miles, 10 miles, and they're using the tunnel and then they use the streets. I think we already have so much traffic in Las Vegas that is only going to increase. What is the incentive for Mr. Musk to finish those tunnels if you allow him to work on the streets? At some point, he would say, I don't need the tunnels. I got the streets. Also, I read an article about Mr. Musk when he disagreed with Trump. He was considering not to use his rockets to go to the International Space Station. He was the only one that could have done it.
Sir, we're not there. Again, to this application, not.
I know, I'm just, it's a matter of the way he does business. I think it's important because I think we're going to open the door to someone and give him too much power, and he can totally disrupt the transportation in Vegas. Like I said, he was considering not to use the rockets. There was nobody else. It's too much power to one single person, and you open the door, and maybe he got too much power that he can disrupt the same thing happened with Uber. I think with taxi drivers, we've been very consistent. You don't need more taxis. You don't need more transportation. I think we're already covered. I think I don't see why. I mean, why you should bring somebody on the streets, somebody else. This is already, the transportation is covered. You got so many taxis making a line to take a ride. We're already struggling badly. We're going into a recession. We got families. Let him finish these tunnels and use whatever he got, but don't let him ride on the streets. That was the plan.
Thank you, sir. That'll conclude your time. I appreciate it. Thank you. Thank you. That leaves us with legal left. All our, that's, she wanted to go. Is there anyone online that would like to speak during comment for this item?
There's no one with their hand raised.
Thank you.
Of the NTA, for the record, I'm Kimberly Maxon Rushton with the law firm Cooper Levinson. What I would recommend is that you have 4 attorneys up here. Each one has the legal right to make an oral protest, and that they each be allowed whatever time they need to make that protest. So I would ask that my colleagues come up and be allowed to participate. If you cut us off, that's fine. We understand, but the record requests that we be identified as oral protestants and allowed to assert our positions.
I think we're going to do oral protest at 5 minutes for the limit for the oral protest.
I think we can do that.
Thank you.
For the record, again, I'm Kimberly Maxon Rushton with the law firm Cooper Levinson, appearing on behalf of the Livery Operators Association. In addition to that, I also am appearing on behalf of Bell Trans, Big Bucks Tours, and LVL. I note this because not only are the members of the LOA taxi members, but the other parties that are being represented today have special service and airport transfer authority. So I also would like to take the opportunity to note the procedural history with respect to this matter. As previously noted, there were 2 PLTIs that were timely filed in this matter, myself and my colleague, Mr. Carson. Following the denial of that, we filed a protest with a request to be recognized as an intervener at the hearing. That was done pursuant to Regulation 706.397. That was previously denied. It was again denied today, in the hearing. What has not been considered is the request for reconsideration of the denial of the 2 PLTIs that were previously submitted. That was filed on September 18th. There was no written notice of it, and so there's been no order given, and therefore I believe that that matter is ripe for consideration. However, based on the fact that I have limited time, I think my time is better spent articulating why the LOA and the other parties noted have a direct and substantial interest in this matter and should be identified as a party. Specifically, the LOA members, as noted, are similarly situated carriers who operate in the same geographic area. Accordingly, pursuant to your regulations, there is a direct and substantial interest automatically granted. It says shall. And since we relied on that word earlier as being critical to your determination, I respectfully submit the fact that as similarly situated carriers, we shall have the right to participate in this matter as an intervener. In addition to that, the LOA submits that it has a direct and substantial interest in the applications or the applicant's failure to meet the statutory criteria set forth under NRS 706.391. Specifically, there has been no market demonstrated. If you take the testimony of Mr. Fingers today, that right there shows you there's no market. He talked about the number of conventioneers and that's supporting the market for the proposed service. Those conventioneers are serviced by bus companies, taxi companies, and limo companies that all operate above ground. You cannot state that an above ground, below ground hybrid transportation service is comparable to that of carriers that perform above ground. Therefore, the market is infirm. In addition to that, there has been no demonstration of safety, as there has been notable media reports about the number of accidents and OSHA violations specific to the tunnel. There is nothing in the application that demonstrates that there is a commitment to resolve those issues and ensure that there are no safety issues. Based on the fact that they have operated for a number of years under the Clark County Commission authority and the failure to present their safety records, this body may draw the presumption that they don't want to present it because it would not be favorable. Additionally, the LOA and the other members submit that there is a lack of financial solvency. It's not with the underlying beneficiary or the developer or owner of the company, but rather specifically to the proposed rates. As you've heard from the taxi carriers who operate along Las Vegas Boulevard in zones at a rate of $23, $25, and $27, the idea of providing the same service for $7, $12, and $14 shows the lack of compensability of these services and the inability for the company to meet the 20% equity based on their operations. Lastly, I think it's important to note the fact that the application demonstrates a clear lack of understanding of the NTA's authority and the statutory and regulatory obligations of a certificated carrier. The reason I note this is because of the fact that there is no evidence in the file or the application that the public was allowed to see. And I note for the record, 90% of it was redacted. So we did not have any information except for what we could read, metaphorically between the lines. But what's important is the fact that they asked for special service and airport transfer authority. Special service specifically states it has to be for a specific reason. There's been no articulated basis for the special service. Airport transfer authority requires you to have authority to pick up at the airport. There's been no demonstration that they have authority to pick up at the airport. TNCs have authority, taxis have authority, and other commercial vehicles do. But in a recent call with the airport, there was no confirmation that they had the authority to pick up at the airport. Therefore, they do not meet the regulatory requirements for airport transfer authority. At best, This request is for fixed route authority. They want to go between their stations. They want to have a specific price. And I'd say sans the fact that they have a time frame that this is a fixed route authority. But again, that's not what they've asked for. So collectively, these things demonstrate the failures of the applicant to meet your statutory and regulatory standards. In addition to that, we note the fact that we have been, the LOA and other members of the public have been unable to access the records of the NTA and specifically the application in this matter. That is a direct violation of Nevada's public records law under Nevada Revised Statute Chapter 239. Lastly, we note the fact that you have heard from multiple people today about the impact this will have on them. Yes, competition shall not be the basis for denial, but that ignores your public declaration of procedure and purpose, which says that every act taken by the authority under this statute shall consider this declaration of purpose. And that states you shall not allow competition that you know will otherwise negatively impact the commercial motor industry as a whole and the traveling public. For those reasons, the safety being the traveling public, that being the primary issue with that. But for those litany of reasons, the LOA and the other carriers have a right to participate in this matter. And again, renew its request to be admitted as a party. If the NTA believes that their analysis is correct, that they've done everything consistent with the statutes and regulations, then why not afford us the opportunity to take this up to a district court and have our voices heard in a contested matter and then allow a court to decide? But by precluding us from participating as an intervener, not only have you precluded us from participating in the matter throughout the application investigation, but now you're intentionally precluding us from taking this up on a petition for judicial review. And based on all of the comments you will hear today, I respectfully submit that that is contrary to your declaration of purpose. And again, renew the request for consideration of intervener authority and status. Thank you.
Thank you, Ms. Rushton. Mr. Kent?
Thank you. James Kent. I represent a number of smaller limousine companies, charter bus companies. I've been appearing before this board for over 25 years, probably about 25 years. I've done a number of applications. I know the process very well. Every one of my clients who has been licensed has had to go through this process. A fully regulated carrier has to prove certain things. As an existing operator, those with a direct and substantial interest, which I don't think can be denied in this, have a right to petition for an intervention. They don't have to, the fact that competition cannot be a basis for denial is only for the application itself. It is not with regard to the PLTI. As a matter of fact, the basis for a PLTI is upon an allegation of effect or increasing competition or some other negative effect that would be detrimental to the industry. Now, with all due respect to the commissioners and everybody else on the NTA staff, none of you, to my knowledge, has ever owned and operated a transportation company. We have a huge enterprise coming in here that obviously, according to the comments, is disrupting the entire industry, causing great problems. How do you know whether it's going to affect the existing industry or not if you don't allow the industry to participate in the application process? That's what the intervention is for. You could say, well, it's going to unduly delay. Well, you put out a scheduling order. You say, this is how long it's going to take. This is what we're going to allow for depositions. This is when you get it done. If you can't get it done, well, then so be it. That's your fault. But you got to give them the opportunity. You indicate that in the one order that I saw, and I apologize, I have not reviewed the entirety of the record, although most of it I understand is redacted. You indicate that, well, staff can adequately do this. Okay, one of the things I was able to see was the tariff. Very short 5-page tariff. Should be easy, right? Well, on page 3, section 7, it says fare, add airport fee. How much is the airport fee? Doesn't say. How does the traveling public know? I've had my tariffs rejected because of that. I've had my applications potentially held up until I prove that. You got to put the numbers in. More importantly, you look on page 2 and as well as the title page, it says the tariff is for service for points and places in Clark County and City of Las Vegas. Now, the way the NTA reads that is one is on one end of the part, either the beginning or the end, and the other is on the other end of the ride. I'd like to note that Clark County can be just about anywhere. City of Las Vegas has to be City of Las Vegas. Neither the Strip nor the airport is located in the City of Las Vegas. My application would be rejected because of that, unless that's actually what they want to do. But everything I've heard about is they want to go to the airport to somewhere on the Strip, both county places. That wasn't caught by staff. And I'm not trying to pick on staff, especially I know now the last couple of months they've been overwhelmed. But this is something that the industry can pick up on that maybe somebody else can't. So to simply say that staff is fully adequate, especially with a substantial application like this, I don't think is a good excuse to deny the PLTI. As to the application, again, I note that, the tariff is incorrect, or tariff will basically prohibit what they want to do. It sounds like they want to use special services as a way to do daily transportation without it being a special event. They just want to be able to go from the hotels back and forth. Generally, when I've asked for airport transfer in the past, I needed a letter from a hotel. It's not just for general public. Airport transfer is generally for groups of people going to the same location or at least the same area. This does not sound like what they're doing. As far as I know, I haven't seen any letter from any hotel supporting this. As Ms. Rushton pointed out, all we heard from was some Las Vegas Convention Authority. Yeah, the Loop might be doing tens or hundreds of thousands of rides. That doesn't mean anybody wants to go above ground in it. I haven't seen anything, and again, everything's been redacted in it. I haven't seen anything that indicates that any of those people in the tens or hundreds of thousands of rides wants to go above ground. I haven't seen anything that the hotels want these guys coming into their business. I have to prove a market. I can't just say, oh, look at the visitor statistics. There's 40 million people coming into town. My guy should get 2 cars. I've been denied on that. And more importantly, you are authorizing, pursuant to the proposed order that you've got, an unlimited license. It says there should be no restriction on the license. 1, if that had been noticed, I probably would have intervened. But 2, and more importantly, I brought an application for an unlimited license 3 to 4 years ago. I was denied. Why? NAC 706-137 subsection I requires a listing of vehicles. You need a number. You cannot just list unlimited vehicles. I don't care how rich the owner is. The idea of a rich owner is not the basis for an approval of an application. You have to fill the number in. NAC 706-1375 Q2 says you cannot place more vehicles in service than listed on the pro forma. I don't know how many they listed on the pro forma. Again, redacted. These are problems that the industry could bring up. I don't know whether staff has addressed these or not. They sure did when I filed my application. Maybe it's because my client doesn't have billions of dollars that has been noted as a basis for the application, but because my guy doesn't have it, he had to follow it. I would expect that it goes for the same thing regardless of how many zeros you have in your bank account. The last thing I'd like to say is I'm worried that, as some of the other people have said, there's potential for abuse. All you have to do is go through the loop. So does that mean that they could install a little 1/8 mile part of a loop, go from the airport, go through that 1/8 mile of a loop, and then do whatever they want? I don't know whether they can. I've had bus drivers years ago, they figured out the loophole was just, okay, if somebody follows us, we're going to go down the state line, because if we go out of state, we're not violating the rules. So if they build a little bit of a loop or whatever, I don't even know how you define loop, suddenly they could drive wherever they want. I think somebody else expressed the concern of people are going to find those loopholes and they're going to wreak havoc in using those loopholes. So I'm not saying they should not be denied or not be denied in the end, but I think a lot more has to be done and explored. And I think there has to be industry input before a license like this could be granted. Thank you.
Thank you, Mr. Kent. Mr. Carson?
My name is Brent Carson. I'm going to just echo and agree with what the 2 attorneys before said for me. but also I have submitted a written protest, and I understand that the board has had an opportunity to review that. So I'm not going to double up and say this. I want to bring up some new issues. And the first one, Kimberly Rushton mentioned, is I believe that going forward on this application is a potential open meeting law violation. And the reason I say that is because the material for public view, i.e. the market, pro forma balance sheet, and pro forma income statement, have been redacted. We have not had a chance to see that. The public has not had a chance to see any of that. And so what is a public record? Well, Nevada Public Records Act says that applies to all books, public records of a government entity, the contents of which not are otherwise declared by law to be confidential. So how do you get a confidential document in front of the NTA? Well, the NRS 706 happens to say 706-1725 states that information that the authority determines may not be disclosed and must be kept under seal. There has never been an order issued by this authority that says these documents, the market, the pro forma, or the balance sheet are confidential. That is the only way in which a confidential record could be submitted to you and be put in front of this. We have a right to see those things. NRS 239 contains this Nevada Public Records Act. It's a manual that's put out by the Attorney General's office. And this is the law pursuant to NAC 239.869. And it says, if any answer is yes, it is a public record. And here's the question. Did the agency require creation or submission and maintenance of the record? Yes, it is your application. You have to submit an application. Within that application, there are submissions of a pro forma balance sheet, a pro forma income statement, and a market requirement under one by itself, and then also under Exhibit M as well. So yes, you need not go any further. These are public records. You can't just deem it, say, oh, this is confidential because I say so. There is a process that must go through, and that is outlined in NAC 706-3949, and then follows all the way through to NRS, which is a statute, 1725, that says only the authority can deem information to be confidential. You guys haven't. There is no order here. You have to go through a closed hearing, and then you have to bring it in front of an open meeting to say, hey, we had a closed meeting and we determined that the X, Y, and Z is confidential. And these are the reasons why. It's never happened. So with that, I believe we have a potential open meeting law violation because we haven't seen what you guys are looking at and what you are going to base your opinions upon for a CPCN, Certificate of Public Convenience and Necessity. We're not on the same, the public, us, we're not on the same footing as you guys. You've seen more. Why? What's there to hide? Those are not confidential because they are part of a submission that the NTA requires an applicant to place in their application for approval of a Certificate of Public Convenience and Necessity. So that's number one. The next one is, how does a hearing officer take judicial notice of a corporate ownership that isn't Nevada's? In the docket, in the material, I think Garrett said that this was a hearing officer Gruber took judicial notice of Boring Company, a Delaware corporation. Now, I don't know this, but maybe she'll help me. They're not a Delaware corporation. They're a Texas corporation. I think Mr. Musk got mad at him when they wouldn't approve his payment package, and he moved it and picked it all up and left to Texas. So how are you taking notice of stuff outside of your jurisdiction when we know that he isn't the 100% owner of the Boring Company? There are private equity groups and other stock issuances. We have no idea who those people are. So you can't take judicial notices of stuff outside of your jurisdiction. Jamie mentioned the tariff. Two last comments. The wording on the compliance order. I've done this along with Jamie probably since 2001, so 25 years. I can't understand this. I don't understand what their pickup, where they're dropping off, where they're going to be doing any of their business. He mentioned earlier, we're going to be down below, and if somebody gives a call, we come out of the tunnel. Is that considered staging your vehicles in a tunnel? Is that considered? Now, that was my part of the underground trip, because it could be to a point where the passenger actually never sees a tunnel. They get a call and they pop up on Paradise, go to the airport, and then go to the Bellagio. They never saw any tunnels. So does that staging in is that what it means? If I just put my car down there, the wording of this stuff has a lot to do with it. I think you guys need to redo it and come up with something else. And then the last thing I'm going to add to this, I'm sorry, is please, there are some legal questions that we know that need to be answered. Please direct these to the public in your consideration of this application. Is Paradise a common motor carrier under 706-036? Is Paradise a common motor carrier of passengers under NRS 706-041? Does Paradise proposed services meet the statutory definition of special services under NAC 706-119 and NAC 706-329? Where is the special event? Where is it? And does Paradise's proposed services meet the statutory definition of airport transfer under NAC 706-115 and 706-348? Those are the important questions that we have here. You're creating a new service just because it's Tesla, something that we've never had. We've never had point-to-point on the Las Vegas Strip. We've never had this because it doesn't exist. People behind me are listening. And I think Mario even said, are the taxi cabs next to come in and apply for special services and taxi and airport transfer and get a per capita rate? Is Mr. Waxler's company, they're going to come in and say, I want per capita on the Las Vegas Strip. Everybody's going to be trying to do this. It's not about the competition. It's about fair competition. They can't have something that we don't have because it does not exist and has never existed under this 706 statutory scheme. Plain and pure and simple. It doesn't exist. And the Nevada Supreme Court has already said that under the Trolley and the Corey case is that you can't make up different definitions on the fly. You have to go through the regulatory 233B framework and reg workshops to do such a thing. So thank you for your time. I appreciate it.
Thank you, Mr. Carson. I appreciate it. Patty Erickson, Ms. Erickson.
Good afternoon, Patricia Erickson from the Jimerson Law Firm, and to be a protestant, also appearing on behalf of Executive Limousine. I'm not going to discuss the same things that the other participants have said to you. I'm going to focus on first the denial of. Closer.
It's real uncomfortable. Yeah, real quick.
The order denying the renewed petition for leave to intervene. The primary legal predicate for that denial is based on an analysis by Judge Posner, which comes from the case of Joe Sanfilippo Cabs versus Milwaukee and Illinois Transportation Trade Association versus Chicago. The analysis by Judge Posner is not persuasive. Okay, no, I don't want to yell. Well, there's some people on the board that know I can yell. All right, so the analysis by Judge Posner is not persuasive or even applicable because it was raised in a factually inconsistent position than what this authority is determining. In the Sanfilippo Cabs case, From 1992 to 2013, the city of Milwaukee had an ordinance which limited the number of taxi cab permits in the city to the number in existence in January 1st of 1992. So while the permits could be sold to others, there could be no new permits issued. And the ceiling number of permits thus declined from 370 to approximately 320. After the permit cap ordinance was found to be violating equal protection and substantial due process, the city then conducted a lottery offering 100 permits. 1,700 permits were sought, thereby suggesting that the market was underserved. And there were other indications in the market that the taxi shortage existed, such as there was only one cab per 1,850 city residents, and which is a much lower number than in comparably sized cities. Based on these facts, in 2014, the city took the lid off the number of permits, which allowed individuals and companies such as Uber and Lyft to obtain permits, which diminished the profitability of previous taxi permit holders who challenged that action as a taking of property without compensation. This legal analysis resulted in all the language quoted in the September 3rd, 2025 order denying the renewed petition for leave to the PLTI. These are not the facts that are appearing that are in existence before the authority. One of the challenges being asserted to the granting of Paradise's application is that it violates the authority's responsibilities under NRS 706.115, subsection C, subsection D1, and subsection E. Today, since we're at the end of public hearing, my count is 17 in opposition, 1 in support, and 5 who left because we took lunch and couldn't come back. These people have told the authority how this application is detrimental to the motor carrier business in Nevada. And given the fact that much of this testimony was given during public comment, it may not be considered by the authority, and it may not be a basis for a district court or Supreme Court to analyze any challenge. In conclusion, I just want to address that while I was the NTA administrative attorney, I was the first to ask the authority to bring the orders granting or denying PLTIs to the authority for consideration. I did that because it protected the authority. It allowed the persons who were denied or granted PLT authority to come before the authority and make a full record of what it was they wanted you to consider. That protected the authority and gave a complete record to a district court or an appellate court. This is the type of case. Well, I recognize during my time, most of the hearings that were held under 3995, the persons re-argued everything that we'd already heard. But not having this application go through that process is resulting in a record which may not support what this authority does. If you decide today to determine this issue without taking time to think about and consider what has been said today and how it impacts the authority's decision. Thank you.
Would you 706, I wrote down perhaps the wrong.
Oh, for the, it's 151115, subsection C, D1 and E, or the rulings by presiding officers being brought before the authority is NAC 706 3995.
And what was I can't find.
Sorry, I lied. I was dyslexic. It's 706151. Yeah,
It's just 151.
151 with the subsections.
I couldn't find it. I thought
You know, I'm dyslexic sometimes with numbers. It's not my best.
this is not a poke at you, Ms. Erickson. I was just trying to follow.
No, I understand.
Oh, thank you. Thank you so much, Mr. Chairman. That's all that I have written down for public comment. Is there anyone else, public comment related to this item? Are there anyone online, anybody online that would like to speak related to this item?
There is no one raising their hands online.
I'd like to send it back to the applicant to clear up some of the issues that have been addressed and maybe respond to some of that to clear things up for us.
Happy to do so. Should we be fielding questions from you, or would you just like us to address them in turn based on what we heard?
Yeah, go ahead and just respond.
Perfect. I didn't want to just
ask as we get.
start monologuing without permission. Yes, I'm actually going to let my colleague Tyler speak first, and then I'll speak.
Awesome. Tyler Fairbanks with Paradise Transportation Company. Oh, Fairbanks. Great. Yeah, so we may miss some things because I know that was a lot of information there. But we just want to start with the classification as special services and airport transfer service. We worked very closely with the NTA over the course of more than a year to determine the specific type of carrier that we should be classified as. And so this was the classification as special services as an airport transfer service that came directly out of our work with the NTA staff. Number two is we're not looking for any special distinction here. We believe we fall within existing types of services within NTA guidelines. And so when it comes to regulations, we're stepping in here looking to be regulated just as these special services and airport transfer service would be. Number three, and this is a very critical point, this is on safety. So the transportation system that we've built to date, and this is specifically the tunnel system at the convention center and beyond, we received an audit from the DHS and the TSA, and we received the Gold Standard Award. We scored a 99.51, which, as far as I understand, is the safest score any transportation system has received. And this is not some theoretical audit of plans. This is actually taking a look at the system in place to see, is this system actually safe? And we apply that same level of safety to all of our operations. Again, safety is absolutely critical to all of the operations from the Boring Company, Vegas Loop Operating Company, and Paradise Transportation Company. Specific to Paradise Transportation Company, all of our drivers are trained and they're employees of Vegas Loop Operating Company. So that's number one. Number two is also all of our vehicles and our drivers are monitored 24 hours by an operations control center. So we have an operations control center that's the brains of our transportation system, and that can see what every vehicle that is part of our fleet is doing in real time. And so that's are the passengers wearing their seatbelts? How fast is each vehicle going? Which train driver is driving that vehicle? And what route is that vehicle driving on? So that oversight also really adds to the overall safety of the system. But again, safety is absolutely paramount to the company. The next one is on the airport. So we have been working with the airport. What's necessary in order to get our approval to provide service to the airport is for us to provide them with the CPCN, assuming that this application gets approved. So step one is to work with the NTA to get the application approved, and step two is to go to the airport with that approved CPCN number in order to be able to provide service to the airport. In that process with the airport, we'll also learn what the airport fee is, which is why we left that open in the application. We want to have the ability to add that airport fee, but we don't have that number in front of us yet. And then finally, just to clear up operations a bit more, every trip that Paradise Transportation Company makes with passengers in it, every trip touches the tunnel system. I think one of the comments made was if a vehicle leaves the tunnel system to picks a passenger up, then can that passenger be transported on the surface to another surface station without touching the tunnel system? That is not correct. Every trip with a passenger in it must touch the tunnel system. I think that covers everything that I had kind of off the top of my head. Ashley, was there anything that I missed?
Hi, Ashley Steinberg, Steinberg. Can you hear me okay? Okay, cool. I'm a little short for this. I can move this down? Perfect, thanks guys. I just wanted to point out a couple comments or a couple observations. The first is that, and I'm not sure how to refer to the interested parties. I'm not sure what the lingo is, but the attorneys who sat up here, they raised no new arguments for your consideration. Everything that they've just spoken about was something that you've already ruled on in your denials of the PLTIs. So I just wanted to point out that these are matters that you've already considered and ruled on. That said, I'm more than happy to continue to address some of the more thematic issues that they had raised, one of which was safety, which my colleague just discussed, but let me reiterate, our safety record is impeccable. And as I advised in my response brief to the first PLTI, they're welcome to our safety records are public record with LVCVA, and they can look at those anytime. And what those records reflect is a truly impeccable record in terms of the safety of our system. And the reason that we have such a good record is because our drivers are so rigorously trained, and the background checks and the drug testing and the vehicle maintenance, everything that goes in either meets or exceeds your existing regulations as well as what the federal government requires. I also wanted to comment on this idea of market. My understanding is that the NTA in your authority is well positioned to determine whether or not a market exists. But the idea of using Mr. Finger's testimony as evidence that there is no market seems to be somewhat perverse, because his whole point was that there are millions of visitors coming to Las Vegas every year, and the more options that these visitors have, the better. And I think that's really ultimately what this comes down to, is that, as Ms. Rushton pointed out in her opening remarks, that there's an obligation here to think about the public interest. Our submission here is that the public benefits from having more transportation options. And that's really all we're asking you to do. We're not asking for special treatment. We're asking for the opportunity to compete with companies that already do operate, the companies that are trying to keep us out. We're not asking for special consideration, for special treatment. We just want to be allowed to be subject to the same regulations that they are, so that we can operate our business just as they do. So thank you so much for your consideration. If there's anything else that you'd like us to address, we're happy to.
We have any questions from the commissioners related to the applicant?
Thank you, Commissioner Teddy. I have a few questions. For the record, Louis Zoka, Commissioner with the NTA. So my first question would be this. My understanding is what necessitated the instant application was the fact that there was going to be an exit made near the airport to be able to traverse to the airport with these vehicles, correct?
Correct.
And is that because the airport currently doesn't allow you to tunnel under the airport?
We're working on that deal with them. So the contract is near finished, but the station design is under review. So because that's an ongoing process, the goal is to do this first, given that the completion of those negotiations and the subsequent construction will take longer than tomorrow.
Assume at some point in the future that you have that tunnel under the airport. Will you need this license from the NT at that point?
Well, I think the goal here is not just the airport transportation, but if it's also the ability to use the tunnels to get to other stations. But for the purposes of your question, I think once the airport station is open, we would have no use for the surface drive. Our goal with this system is in service of tunnel transportation to reduce congestion at the surface. The goal is not to suddenly clog the roads with additional vehicles. The whole point is to get everyone underground.
And it is my understanding that you have various approvals with municipalities and the state. Could you please tell us again what those approvals are?
Sure. So you mean with respect to Vegas Loop?
Yes.
Okay. So what we have, because there's two jurisdictions in the territory that we cover, there's the city of Las Vegas and Clark County. We had to do this process in parallel twice. And what we did was a franchise agreement, what's called a franchise agreement with Clark County, and then a monorail agreement with the city of Las Vegas. And a monorail doesn't necessarily mean a train that goes on tracks. It's just a statutory creature that refers to the type of guided system that we operate. So monorail is a bit of a misnomer. What those agreements done, which by...
May I stop you there for a second?
Sorry.
So in part, the intent of this was to replace the transportation that the monorail was initially providing and now put it underground, correct?
No, we have nothing to do with the existing monorail, and this wasn't meant to replace it or augment. It was completely separate. It's just that's the term. That was the category that the state legislature decided when they decided what a monorail was. And then I think that it became part of the Clark County Code, and it originally did apply to just the monorail, but we're the closest analog for us was that at the time when we were doing the tunnels. So they were like, okay, you're technically a monorail too. But it really didn't have anything to do with connectivity to that monorail. It also,
Understood.
yeah,
Yep.
It also just so happens that the convention center owns the monorail now. They had purchased it after we came into the picture. But again, that fact doesn't bear on this. So what we did with Clark County and then separately with the city of Las Vegas is get a franchise agreement and a monorail agreement. And what those agreements did was twofold. Number one, they give us a business license to operate. So that's basically the legal authority to operate the type of business that we were seeking, sort of similar to what they would grant a utility, right? This is what you're allowed to do in this area. The second thing it did was give us access to public right-of-way. So what we had to do was submit an entitlement map as part of this process, which is the map of 104 stations that my colleague Tyler referenced earlier. And all of those stations, we needed permission from the private property owners to be on that map. And then zoning votes on it, and then the county or the city, respectively, votes on it to give us the ability to access the public rights of way to get to those stations. So for example, the Paradise tunnels that we referenced earlier are entitled subject to the franchise agreement. And then of course, we also have to have our Clark County business license and our state corporate registrations and all of the normal things that companies have. And then separately, we will need authority from the airport, as we discussed earlier.
Thank you. No more questions.
If I may jump in on that, can you explain the airport authority process for us, what that looks like on your end?
Sure. It's actually less discretionary than you would think. It's my understanding it's an online application that anybody who wants to operate a pickup or drop off at the airport can submit online, but there's a field there that says CPCN number. So we can't apply for that until unless and until we have that number. And then in their discretion, I guess they can grant us the ability to do it. But then we need to also comply with their technical requirements. So they, for example, they have a geofencing requirement that kicks in their airport fee that we're going to have to pay them when we drop off or pick up. And the way they do that is they install this monitor thing. I'm so not a technical person, so I know the term is not monitor thing. It is something else. But thank you very much. Transponder, I should have known that. They install a transponder for us. And so we're subject to the same geofencing that anybody else is subject to. And we have to comply with all their rules too. And importantly, in addition to the tariff that would be charged for the surface and then the separate fee that would be charged for using the tunnels, we also will pay the pickup and airport drop-off fee that everyone else has to pay as well. So there's sort of multiple components to what the customer ends up paying at the end.
Thank you. And were you informed by the airport that you could not apply for that service until you obtained the CPCN? I mean, that was information that the authority had received. I just wanted, okay, thank you.
Okay, thank you so much, Mr. Chairman. I'm still grappling with a couple of things here because under special services, well, let me get my. Oh yeah. Well, let me get. Hold on. Let me get my notes up here correctly, and then I will. That's not the right one. So under special services, NEC 706-119, special services are defined and they're also included in NRS 706-171. They mean the transportation of persons who have acquired the use of a vehicle for a special event or for the use of special purposes approved by the Nevada Transportation Authority. You fit that. Okay? That's a neat little category that you fit in. What it does not include is the charter bus services by bus, charter services by limousine, scenic tours, or airport transfer services. So I'm trying to understand how that piece, because as I started to unpack this and try to understand this, and by the way, if I was a hearing officer, I would not give you a decision today. I'd really want to digest this over time. I'm not telling you that that's what's going to happen, but I mean, there's a lot to digest here. So I was under the impression that part of what you were asking for was indeed an airport transfer service. Am I incorrect in that?
No, that's correct. The reason we applied for both the special services and the airport transfer service is exactly like to your point. We applied for each. The special service allows us to go to the many stations that are on our approved entitlement. The airport transfer service is what allows us to provide service to and from the airport.
Okay. All right.
And there have been many NTA applications that have done the same thing.
And look, and I'm not going to try to deal with what's happened in the past. I want to deal with what's in front of me right now. And I'm not going to compare you with those and try to use those as the standard, nor will I allow these to be the standard for you. I want to try to understand this as it sits before us. That's me personally. I'm not going to speak for the other commissioners. But I did make a few notes, and I think that some of this is sort of important. And this is where we have to sort of put on a different cap and say, okay, how do we deal with this? And one of the things that I've had to look at is equity. I need to treat you. I don't care who your owner is. I don't, you know what I mean? It's not one of those scenarios. I care who the owner is if there's an issue with that, but with respect to whether you've put in an application or they've put in an application, I have to treat those applications with the same blind eye. I have to look at them and say, do they fit into these statutory requirements and regulatory requirements? Now, that said, I'm also, I'm not going to pull any punches here. I have a little discomfort with approving just a blanket approval on the surface, knowing that the tunnels are coming. I'd like to put a timeline on this, commissioners. I'd like to say that we can even put a percentage of timelines. We don't have to say, well, tunnel A, tunnel B, and tunnel C have to be completed by this particular timeline. We could say a percentage or these many miles of tunnels have to be completed. And what it does is it puts the boring company on notice to do what you said you were going to do. Not with this agency, but with Clark County and with the city of Las Vegas, which is really part and parcel of what you're asking for. You know, you want to travel below the surface, and I admire that. I think it's novel, and I think it's it's something that will ultimately change the face of transportation. Probably not in my lifetime, but at some point, people are going to look at this as a real option in the future. This is why I hate laptops. I have a lot of windows open here, and I'm trying to find my other commissioner. Mr. Chairman, if you want to proceed, I need to find something here because I've got.
Sure. And I had a question that came up. If the board were to grant authority, and there's a competitive process for airport transfer at the airport, what happens if you don't obtain the licensure at the airport?
If we can't get approval from the airport, we would not make trips to and from the airport. We would just operate the special services portion of this application. So to and from the other stations, not the airport.
From what I understand, though, about the airport process is that it's not as discretionary as something like this is. I think it's just you apply online and you get your permit unless there's something wrong. So whereas the station negotiations to actually build that's obviously highly discretionary, right? And it's highly negotiated. Our understanding was that this process was much simpler. So we're not anticipating any issues. And I think also they have the obligation to be non-discriminatory in their, allocation of these permits.
Okay, thank you. Thank you, Mr. Chairman. I found just a piece that and I'm an unusual writer. I make a note and then I add it to another note and then add it to another note. And so then I have to piece it all together. But here's where our hands become tied. And it doesn't matter whether I'm dealing with anyone in this room, anybody, it doesn't make any difference. Your technology is novel. There's no question of that. But the authority's responsibility is unchanged, and we have to apply the same legal standards of fitness, necessity, and compliance that govern all other Nevada carriers. We have to apply the same standards across the board, regardless of what it is. So I can't look at how your innovation might alter transportation in the future. I can't base my decision on speculation, nor can I base my decision on emotion. I can't do that. That's the statutory guidelines and the regulatory guidelines don't let me do that. Although I'd love to do that. I'd like to say, you know what? This is an emotional scenario. And I can speculate what might happen, but I don't know about any of you. My crystal ball is as clear as mud in terms of speculation and how things will happen. And in fact, I gave a talk on this very thing recently at the IATR. That said, I still have some questions about how this will all work together and the timing of it all. And so I would be more comfortable, commissioners, with putting some type of a condition on this to say we have to meet some timelines. That's my comfort level, and I'm going to leave it at that and let some other commissioners chime in. Thank you.
I think for me, there's been a lot of discussion about the proposed order. I would like to just have that read in so we can have some sort of discussion and clarity related to that. Thank you.
Garrett Hammock, financial analyst. I'm going to ask for a little bit of grace. I found one piece of information, which is the actual wording that would be on their certificate that I should have read probably in my opening. So I wanted to read that now. So the actual certificate would read, with their authority, would be operate as a passenger carrier to provide airport transportation and special services within Clark County, Nevada. The certificate of public convenience and necessity covers all Vegas Loop stations that are approved by Clark County Franchise Agreement dated October 20th, 2021, and the amendments thereto. The use of each station is contingent on a permit of occupancy provided by the county and showing to the authority that the station is operational. Each and every ride provided by Paradise requires use of the parent company Vegas Loop underground tunnels and cannot be completed unless Vegas Loop underground tunnels are used during each and every ride. Each and every Paradise ride would be point-to-point transportation at a per capita rate. Paradise is not restricted to the number of vehicles. However, all vehicles must be part of the parent company Vegas Loop fleet currently used in the underground tunnels. Rates charged by Paradise are in addition to those charged by the Vegas Loop for the portion of the transportation provided within the tunnels. It also stated earlier that the current fleet size is 102 vehicles. And then I have another piece of information regarding the PLTIs that I found relevant. Upon the initial public notice on September 20th, 2024, we received quite a bit of complaints from the public and basically telling us that it was far too redacted and the public couldn't get enough information needed to file any sort of opposition in form of a PLTI. The deputy commissioner reviewed the publicly noticed application and deemed it too redacted. The deputy commissioner then worked with the applicant to remove some of the redactions. Paradise then revised the application and submitted on November 4th, 2024, a revised application. That revised application was then re-noticed on November 5th, 2024, with a full 30 days for anyone to file a PLTI, for the public to file a PLTI. After that point, we started receiving PLTIs. Point being, it seems like after the application was revised, the public or the lawyers were able to find enough information from the application in order to file their PLTIs.
Thank you. Any commissioners, anything?
Commissioner Teddy, I would like to ask some questions from our legal counsel. Thank you. Ms. Wilburn, are you familiar with this is going to be relevant to the application in terms of the requirement for application. Are you familiar with the Bali High Golf Course? I am. And do they have caddies that provide transportation to golf players and motorized golf carts?
They do.
Why doesn't the NTA require a CPCN for Bali High Golf Club?
Because, can I answer? Because it's a privately owned club that doesn't go on a public roadway.
So by not being on a public roadway, they would be exempt from our licensure requirements. Is that correct?
That's correct.
And if the vehicles that are owned by the parent company, and in this case operated by Paradise, if they entirely remained in the tunnels, would the NT have any jurisdiction to regulate them?
None whatsoever.
So this whole application is necessitated by the fact that these vehicles are exiting near the airport. Is that correct?
That is correct.
Thank you, Ms. Wilburn. So with that, having consulted legal counsel on that particular issue, really this application arises because of the exit that's being made near the airport. And I think as long as that is the case and this does not morph into something else, I think with staff supports the application, I'd be willing to support the application as well. And I understand the chairman's concerns, so I think maybe we need some more discussion on that. Thank you.
Thank you, Mr. Zilka. So on that same line of thought, if it were merely from the airport to the tunnel, I think that I would feel the same way. But where I have a little concern is because they're not just going from the tunnel to the airport or from the airport to the tunnel. They're also going to access locations that stations will ultimately be at, which is why I'm asking for, some kind of a reasonable timeline. And look, and I'm not telling you, can you have those tunnels done by 3:30? That's not it at all. It's putting a reasonable time for this to occur, because otherwise it becomes just another CPCN, and the tunnels that are at these particular stations, that all that point becomes moot. That's the first piece. The second piece that I'm having a little bit of discomfort with, at least until I can better understand this, and I don't think I can better understand it without some time. They're asking for 102 vehicles, if I wrote it down correctly, with unlimited vehicles. So can they just at any time add another 100 vehicles, or how is that going to work in this particular application? Or 500 vehicles?
I mean, as it reads, it is no restriction on the number of vehicles. So right now their fleet size is 102. So as I read it, yes, they could add more as they get more vehicles, as long as they are part of the parent company Vegas Loop fleet currently used in the underground tunnels. And yeah, as long as they're part of that fleet, then
There's no ask whatsoever. They don't have to come in and say, hey, we need to increase capacity.
that's how I read it. But I may be wrong. I did not work directly on it, but that's how it reads in the certificate wording, if you want to review it.
Just trying to unpack.
Yeah.
I may not be 100% accurate, but they would still come not before, but they would go through compliance for the approval of those vehicles to be operated, correct? I mean, they wouldn't just be able to put them in service. There would be paperwork and a process at the NTA to add each and every vehicle. They would be inspected just as our other carriers are.
Administrative Attorney Yonit Wilburn, I do believe that's the case. I do understand the concern about the no restriction on vehicles. This is a compliance order, and you can work with the applicant to start with 102, which is what they listed, and state that they want further vehicles. They need to come before the authority to ask for an expansion of authority. I think that's something under our purview here, and I don't think that's inconsistent with something that Paradise would be willing to do. It's just an expansion of authority versus a full application for authority itself. But that is something I believe in approval that the commission can do if that's the one hangup, that it's fully unrestricted to the number of vehicles.
Thank you, Ms. Wilburn. I appreciate that. So commissioners, that's where I'm a little concerned with that. While I realize that they have to have permitted drivers and they have to have those vehicles inspected, those are very simple kinds of things to comport and comply with. But just adding additional vehicles, I think we make pretty much everybody do that. Tell us that you're going to add vehicles every time you even, for a special event. I've signed things off that says, we're going to add another 15 vehicles because there's a special event in town. Man, if you need 15, I'll give you 20. I'm happy to do that because I think that's a valid thing, but I want to know that you're adding 15 or 20 vehicles. I want to know that. So that's a piece that I have that I'm concerned with. And again, I would like to put some kind of a reasonable timeline on a percentage of the tunnels to be completed. Because again, that's what this whole question is. It's a you know, a novel technology. And I love it. I think it's groundbreaking. I literally, and I've compared it to this. And I'm not talking about just transportation now. I'm talking about municipalities using this technology ultimately as acquisition of right of way that they can't normally get, where you've got an intersection and then the only way that you can expand the capacity in that intersection is via eminent domain, or go up or go down. And so I think that technology will be applied at some point in the future, but we've got to have a proof of concept that, hey, yeah, this works and it's safe. Now, we're not here to determine that type of fitness, but we are here to determine what valid challenges would be safety deficiencies, insurance non-compliance. And when I say those safety deficiencies, I don't mean like when they're inside the tunnel, when they're outside the tunnel, when they're operating on the streets of Clark County, that we don't have inordinate safety issues. I'm not terribly concerned with that because I think the vehicles are, they're safe, they're new, and I think your drivers are highly qualified. So I'm not going to question that piece. Financial unfitness, fraud or misrepresentation, that's very subjective. Somebody's going to claim that there's fraud or misrepresentation, and somebody's going to say that there's not. So that's a very subjective point. But public necessity, and that's a more difficult piece for us to determine because we're still in, and with all due respect, a proof of concept phase. We're still trying to prove all of this out. Once it's inside the tunnels and you've got 5 years of data and you can demonstrate that, you're carrying X amount of people, you're actually reducing congestion, you're mitigating that, you're doing things for air quality, and you're not affecting those. And by the way, and this is not a defense of them, and I know this for a fact, I know this. We've been talking about autonomous vehicles. They're great to just move from one point to another. But if you got to carry a bag and you're somebody like me and you've got 2 or 3 or 4 bags and I can't haul that stuff, I love a driver. Just telling you. I love that. I love that assistance. So, and I'm not looking for any comments on that. I'm just telling you that I love that assistance. So this is not going to this will have a driver, but it's going to be a different concept. Invalid challenges are mere competition, sadly overlapping service areas. I get that, but those are invalid reasons. Speculative harm. I mean, that's what we're dealing with right now. And that's the very difficult part, is we don't know what the actual harm is. And that's the hard part for us to unpack all of this. And then of course, just the whole emotion behind this. And look, and I get that. I don't want to put anybody out of a job. In fact, if anything, I want to put people to work. So I would like to see, commissioners, some conditions on this. And as long as I think we can come to some agreements with the applicant that we can all say, yeah, those are conditions that are reasonable, I think I could support this. If I can't get those conditions, for me personally, I'm going to have a difficult time. Thank you, Mr. Chair.
Thank you. For me, I would entertain a discussion related to the time on construction, setting some sort of limit. And I share similar concerns related to the amount of vehicles that would be in operation on day one. We flip a switch and 1,000 vehicles flood, the market. And I don't know if we maybe need to discuss a little bit more clarity in what's in this proposed order. How far would a vehicle travel to make its way into the tunnel? I mean, is it 10 miles to get to the tunnel, 5 miles to get to the tunnel? I'd like to see something a little bit more specific to that.
Yeah, the map that's part of the. Oh.
Maybe help him complete his thought, because I really like where you're going with this. Maybe we can set a limit on that. and say you can't travel more than
On the surface.
on the surface, X amount. And I'm not trying to put words in your mouth, Mr. Chairman. I'm just asking, is that, okay, okay, and that's why I wanted to just have some clarification so that you guys maybe knew where we were going with this.
You want to respond to any of that, Mr. Fairbanks?
Yeah. Oh, no worries. Yeah, the map that we provided, I think the maximum surface drive distance would be on the order of 4 miles. And that map is in the application. And then responding to the 2 other items, one is some sort of timeline. I think Chairman Hartung made a comment about the possibility of this approval being conditional for 5 years. I think that's reasonable. We're certainly incentivized to build the tunnel and build out the transportation system that we've proposed to build here in Las Vegas. That's what we are working extremely hard to do. And so I'd be comfortable with setting a time horizon on this approval. I think 5 years sounds reasonable, but you guys let me know what you think on that.
And you're not saying 5 years for the complete project. It's just 5 years to have a portion of things up and running.
What I was saying is 5 years for us to be able to provide transportation services on the surface. So we would be trying to build out our entire project for the next 5 years. Yeah. So within 5 years, we want to have the bulk of this system complete such that we no longer need that surface transportation.
This is Ashley Steinberg, Steinberg. I don't know how I almost got that wrong. But with the opportunity, of course, to renew or appear before you again as it sunsets, we would love the opportunity then to renew it if everyone feels like that's a viable way forward. So we don't want it to be, you can never apply after 5 years.
You raised my point. I was going to address that same issue. Thank you.
And then the last note was on the number of vehicles. It was our understanding that anytime we wanted to add vehicles, we would have to go through an NTA approval process in order to add vehicles.
So the way the proposed order is written is there's an unlimited number of vehicles. And basically what you would do is that the process is you'd go through a compliance process to just add vehicles, which is a NTA inspection, pay a fee, get a sticker, those type of things. It wouldn't be before us anymore. It's an in-office process.
Administrative Attorney Yonit Wilburn. I understand this is a compliance order, but it will be rewritten depending on what the commission votes on. So if the commission says, as of this point, Paradise is approved up to 102 vehicles. If they need more vehicles or would like more vehicles, they'd need to come back for authority of approval for expansion. I think that's totally within the realm of what you can do. The compliance order is going to read with what the board rules today. And I don't think that's an unreasonable ask. And I think based on what Mr. Fairbanks and Ms. Steinberger are saying, that's what they were told, that if they want to add more vehicles, they have to come back for authority to add those vehicles. So I think maybe that was just put in an error, because what I understood was 102 vehicles. And if they wanted more, it just had to be part of the Vegas Loops fleet, but they did need to come back to the authority to ask for those vehicles to be added. Essentially an expansion of authority for vehicles.
Yeah, it's just whatever you would do with anyone else is what we would do.
Well, under that expansion, don't we normally try to ascertain need? In other words, you know, if company A wants to come in and he says, hey, I want to add another 100 vehicles. And you say, okay, we're going to allow you to add another 100 vehicles, but what we're not going to do is we're not going to ascertain that there's even a need for those 100 vehicles. And so that's the part that I would like it to come back, maybe even at least just to a hearing officer, so that it is somewhat done publicly. And you don't need to answer just yet, Mr. Hammack. I'm just trying to express my thoughts in the open. this is a tough thing for people to swallow because you came in under the guise of one thing of being in the tunnels, and now we're saying we're not going to be in the tunnels. I get that. So I'm trying to figure out, sort of a happy medium here. I am not going to pull any punches again here. I have a little discomfort with 4 miles. I was hoping you were going to say, a couple of miles, but 4 miles that's a stretch. That's a good distance. The 102 vehicles, I think I can get to that point. I would like to see percentages of the tunnels done on, sort of given dates. So you say, okay, well, in 2 years, you're going to have 20% of the tunnels done. In another, year after that, you're going to have 40% of the tunnels done. And another year after that, or 2 years after that, you're going to have 70% of the tunnels done. And try to make sure that we're accomplishing and we're hitting some benchmarks along the way so that they don't come back in 5 years and go, hey, we're sorry, we didn't build any more tunnels, but we need another 5 years because, we, for whatever reason, ran into rocks and couldn't dig the tunnel. So I think it's reasonable for me, at least, to ask for, some type of benchmarks along the way. Go ahead, Garrett.
Yeah, I'd be happy to speak to the unlimited and how it works. So the unlimited certificate, if they are unlimited, they only have to go through the compliance side, basically making sure they're safe, getting them decaled. If they are limited to the number of vehicles on the certificate, then they have to file an actual expansion application, go through the financial process, justify market, and then they also have to go through the compliance side. So it is a little bit more difficult if they have to go through that expansion process if they're limited to the number of vehicles versus unlimited.
And sadly, you're probably not going to know this, and this isn't a pejorative comment about you. This is probably a Liz question. How many unlimited licenses do we have out there?
I know not very many, but I can speak to a number. There's a limited amount.
8?
Yeah.
8 unlimited. 8.
Yes. Yeah. Sounds about right. So I would say it's.
So this is hen's teeth. It's rare. They were grandfathered.
Administrative Attorney Yoni Wilburn, I think we're getting a little off topic here. I don't think Paradise is here asking for an unlimited license. Like I said, I think that was a mistake putting in there. I think they're asking for 102 vehicles, or based on what they're saying here today, they were saying they're fine limiting it to 102 vehicles. And if they want more vehicles, they understand they need to go through the expansion process to show 102 is not enough to service what they're doing. Here's the market to show that we need to add another 50 vehicles or so. So I don't think they're here asking for an unlimited license, and I don't think that's what we're here trying to decide.
Garrett Hammock Financial, but as it's written.
That's what I'm just going off of what's written. And I understand that. That's why I'm bringing these questions up. And I'm not trying to be adversarial. I'm just saying that's what's in writing. And one of the things I've learned over the many years that I've been involved in the municipal process and making a lot of really hard decisions, words matter.
So if we talk about an expansion of authority by adding vehicles, would they come before the authority for 1 vehicle, 10 vehicles, 20 vehicles? Do we want to see them for every vehicle, or would we consider, if you want to add 10, then we'll bring it before the authority again?
It would be any vehicle above and beyond what you state on their certificate. So if it's 102 vehicles on their certificate is what they're limited to, if they want to go to 103, they got to do an expansion application.
I think that's reasonable, Mr. Chairman, for the simple reason that otherwise they come in and they do 2, or they don't even come in, they do 2, and then they do 5, and then they do 4, and then they do 3, and then 2 again, and then 4. And that's, I'm not this is not accusatory. I'm talking about just the generalized process. So I think, I mean, I want to see all carriers succeed. I want people to come to Las Vegas and experience things that they've never experienced before. And all carriers are involved in that. You know, I mean, it's the charm of Las Vegas. It's coming here to see things that you've never seen before, do things that you've never done before, and you know, just it's a destination.
Do we want to try to formulate some conditions that maybe we can take a vote on and move it along?
Radhika Kunal for the record. Before we go into the motion, I just wanted to clarify a couple of points that were brought up during the protest, especially relevant to OML. I would like for the staff attorney to put on the record when the notices were sent out and when were the background information uploaded. That being said, the confidentiality issues are not controlled by Chapter 241. They are controlled under Chapter 706. Both of them are not, I mean, the confidentiality issues are not so relevant to OML. However, I just want to make sure that the public had enough information, especially with regards to the background information, which was accessible to the attorneys and public to review and come back to NTA if they had any concerns or questions. Thank you.
Administrative Attorney Yonit Wilburn. Yes, I was a little confused by Ms. Rushton's comment that the documents weren't available to the public. I mean, I understand during our shutdown, they weren't available, but they've been available, and the application and everything submitted with the application has been available to the public since November 5th. The backup documentation with regards to this agenda went up on Friday, but that's all the documentation for everything on the order. However, the application has never been taken down or not available to the public for view since November 5th of 2024. So that's, I believe, what Ms. Kuhnel was referring to. It's always been available for public inspection. And with regards to the confidentiality, most applications that come through have items listed as confidential, and I've never seen an order issued by the authority to keep these documents confidential. That's never been, a full order has never been put out to keep items confidential. I've never seen one. I usually sign most orders because I'm the administrative attorney. I'm sure Mr. Kent, Ms. Rushton, Mr. Carson himself have had applications with confidential packets, and they've never asked for an order and never received one. So to that point, that's the authority determines it's confidential. It's confidential when it's asked by for the applicant.
Go ahead, Mr. Kenton. Just come up to the table, please, so we can make sure it's recorded.
James Kent. Yes, I agree that there are certain things that come in, such as bank accounts, tax returns, things like that. Those are automatically deemed as confidential. But if in fact I want my market to be kept from the public eye, I have had to file a motion with the NTA, get a hearing officer's approval that that is now confidential. If there's an intervener or somebody else, they then have a right to oppose that order and have it opened up for whatever reason they think, and I have to prove to the commissioner or to the hearing officer that there's a basis to keep it confidential. So that's the process we've had to go through. Thanks.
Mr. Fairfield, tell me again what's the total number of miles of tunnels that we're going to build that are unbuilt? That's what I'm interested in, not that are currently built and in use.
We have another about 58 miles of tunnel to build.
58 miles. Okay. So if we were to put a 5-year timeline on this, it would not be unreasonable to say you guys need to build 12 miles of tunnels a year.
I don't think that we want to agree to a milestone number of tunnels to be constructed per year. What we're comfortable with is accepting a 5-year time horizon on the overall approval. But like I said, I don't think we want to get into a set number of tunnel miles that we're building each year.
There's the construction delays, and I mean, there could be all kinds of reasons why that wouldn't happen, right?
That's correct. Construction delays, permitting. I mean, another piece of this is we actually do hope that the system expands beyond the 68 miles of tunnel that we're proposing to build, which again is why I think setting a 5-year horizon on this particular approval is the right approach.
Administrative Attorney Yonit Wilburn. Chairman Hartung, I understand where you're going with this, and I believe that Paradise is comfortable with the 5 years. I think setting a specific amount or mileage of tunnels is a little too restrictive in the sense, like you said, construction issues, weather issues, certain things along those lines. And I think that it's just too restrictive in the sense that we would never treat anyone else like that. And we're doing this because it's them. So I do take a little bit of issue with a specific mile of tunnel with regards to it being challengeable in some sort of sense. But I don't think a time limit like in 5 years, you should have 80% of your tunnels done. Or in 5 years, this CPCN lapses and you need to come back or something along those lines.
I'm sorry, I just have a question. So what does that look like at the end of 5 years? We have a hearing to potentially take a CPCN away?
Administrative Attorney Yonit Wilburn. I don't know. You're going to have to style that. So I don't love that, but I do like you can do status checks because it's hooked to another operation, correct? I don't have a problem with that. But like I said, I take issue with the exact mileage number, putting in an exact number of miles that has to be done. For example, if you come back in 5 years and say, hey, 80% of your tunnel is done, great, you can continue on. Or 75% of the 57 miles left is done, no problem, keep continuing on. Something along those words, I think would be appropriate versus like, hey, it just lapses and now you have to have a new application.
So we'd be working something so similar to like an order to show cause hearing, right? At the end?
I don't want it to be called an order to show cause because that means you've done something wrong.
Okay.
So that's not what it is. It's essentially a status check on the CPCN.
I'm just curious what it looks like when we bring them back in at the end of that 5 years before the authority to justify.
Right. So this is, excuse me, sorry, I didn't mean to interrupt. Administrative Attorney Yonit Wilburn, that is the issue with putting this time limit on. Because of issues that they could run if they're constructing something underground. So, for example, I guess I don't know, I'm not really, but a building permit. Hey, you have to have 80% of your building constructed by this. And if you don't, you have to come back for us and ask for more time. I think it looks something akin to that if they were going to agree to that, not something like you have to have 17 out of your 30 floors completed by this. And if you don't, then we're yanking your permit. Does that make sense? I think it needs to be styled more in that fashion.
Right. And that's where I was going. I don't want to, at the end of 5 years, go to a business that's in operation and say, okay, you didn't do what you need to do. We're taking it. So we'd have like a compliance check at the end of that 5-year period, and then we'd address it then.
Administrative Attorney Yonit Wilburn, I think that's the appropriate thing to call it, a compliance check at the end of 5 years to see where you are. And if we're okay with it, we move forward and grant you another continuance. If we're not okay with it, we need to come back and have a full hearing as to why we should allow you to grant the continuance, something along those lines. I think that's more fairly situated than a very specific number.
But I'm just gonna, again, play devil's advocate here. Remember that regardless of the number of miles of tunnels that they build, once they're underground, we're not administrating them. Right. We're only administrating them for above ground use. So that's really what's in front of us today.
Do we want to try for some sort of motion?
Before I try for the motion, can I just ask them a couple of questions? Thank you.
Before you ask them a couple of questions, can we take a 5-minute break? I'm sorry.
We will. It's 3:30. It's a good time for a 5-minute break. Let's take a 5-minute recess and then we'll come back, allow everybody to use the restroom. Thank you.